Yes, Mr. Ewan.
Yes. A few points that perhaps I should have covered earlier, but might have some significance in the light of the way the argument's gone.
Are you sweeping up, are you?
Sweeping up, yes. You, my Lord Justice Snowden obviously was expressing concern for minority small shareholders caught up in these kind of arrangements. Parliament also considered the position of small shareholders. If you turn to section 137, you will see subsection 2. Though shareholders who hold 5% or less are not subject to section 137. So they will get their relief whatever the position is.
Yeah, again, I'm not sure that's entirely an answer to the structural.
It's not, but it's an answer to Parliament has considered.
In part.
Sorry.
Yes, I mean
it's quite an important part of the provision, because if you have a 5% holding, whatever tax avoidance schemes are being, even if you're engaged in one, you get the relief. So it is quite important. And I would submit it does show that Parliament is recognising that small shareholders could be caught up in a situation where maybe a larger shareholder is involved in a scheme, they're not involved in it, and the line has been drawn at 5%. They've said if you've got 5% or less, then you simply don't have to worry about it. You get your relief. So that's the first point. The second point is you were asking, well, one of the questions was asked, well, why are there not more cases going through? There are a number of reasons for this, I think. One is, as far as corporate shareholders are concerned, it's very unusual for them to have to consider these provisions, because in most cases they would qualify for substantial shareholding exemption if they're selling ordinary shares in a subsidiary. The reason they didn't in this case was because of the unusual circumstances that these were shares in this was a joint venture, and their shares didn't carry any dividend rights. They had some kind of special royalty agreement. So one of the conditions of getting substantial shareholding exemption is that you have a certain 10% of dividend rights, so they didn't qualify.
So what happened, when does this normally apply? Because very few shares carry no dividends.
It would normally apply to individuals, because individuals can't qualify for substantial shareholding exemption. Oh yes, sorry, my other friend says it's got to be a trading company, yes. So if they're selling an investment company, for instance, they wouldn't qualify for substantial shareholding. But if it's a trading company, yes. But it will also apply to all individuals who are involved in exchanges, because they don't qualify for that.
And we haven't looked, have we, at the statutory provisions concerned with the SSE? Where are they?
No. Well, I'll take you to them briefly, but before I do, can I just, while we're here, look at section 138, because I haven't mentioned that. You may be aware of it. It's the clearance procedure, where a taxpayer can apply to the revenue for a clearance of a transaction that's going to take place. And if they give the clearance, obviously on the basis of full information, then that's binding thereafter.
The taxpayer can't. The taxpayer.
The company can apply, all right. My learned friend is making the point that the company has to apply. I'm not sure why that makes any difference, but anyway,
okay.
Can apply. And I'm just saying that in practice, that's a reason why taxpayers will apply for clearance. They don't get it very often. They will either amend the transactions or not do them or whatever. Just a reason why it doesn't come up so much. In this case, they were going to do it anyway, and they applied for clearance, but I think, well, the result didn't come until after the transaction, but it was a refusal in any event. So can we look at the SSE provisions? They're at the beginning of the bundle. The main exemption is in subsection 1 of
Schedule 7AC.
Yeah. And you'll see that, again, on a company, investing company, disposal of interest in shares in another company, it's not a chargeable gain if the requirements are met. And then some of the requirements are in sub 7, which is on page 5. Must have held a substantial shareholding in the company invested throughout a 12-month period beginning not more than 2 years before the day in which the disposal takes place. That's of course why in this case they had to wait for 12 months in order to qualify for relief. And then para 8, which is on page 6, meaning a substantial shareholding. If you hold not less than 10% of the ordinary share capital, are entitled to not less than 10% of the profits for distribution, and not less than 10% of the assets from winding up. And if those conditions are satisfied, all the conditions are satisfied, then the disposal is exempt.
There's no anti-avoidance.
There's no I'm not sure. Hmm? Yes, sorry, yes, there is something. I don't think it's here. Yes, I don't think it's relevant in this case, but it's not.
Well, it might be relevant. Well, just tell me where it is, and then we
It's
can
in
look it up.
total para 5? Yeah,
Para 5.
para 5
Of what?
of Schedule 7.
7AC.
7, yeah.
Of Schedule 7AC. Yeah.
Yeah, it doesn't look as though it would be applicable at all on the fact on these kind of facts.
No, I'm just looking for whether one can construe out of it some legislative scheme, that's all, or legislative understanding. Anyway, we'll look at it separately.
We haven't had an argument based on paragraph 5 yet, so we'll see. But I mean, our point on this is that we're not looking at the substantial shareholding relief, we're looking at the statutory purpose of section 135. That's what's being, we would say, being circumvented.
Mm-hmm.
The way in one of the devices to circumvent it, obviously, is the claiming of the relief. That's not relevant to the question of whether there's tax avoidance, I would say, in this transaction.
Yeah. Mm-hmm.
Can I just then finish with the, unless you'd like more on that, with the Upper Tribunal decision?
Which one? The Upper Tribunal.
The Upper Tribunal in this case.
Mm-hmm.
And the core really of it is, in my submission, paragraph 42 and 43, which are on pages 62 and 63. Paragraph 42(1), which is recording the submission that I've been making today about the way that the provision is to be interpreted. And in 43, the tribunal says the proposition set out in 42(1) is not set out in section 1371 itself. I see no reason why it should be inferred to be Parliament's intention. Well, I've made my submission of why you get that proposition from the words and the structure of section 1371. And then, so they went on, having rejected that, to decide that it was for the tribunal, the FTT, to decide as a matter of fact what were the relevant arrangements in any particular case. and concluded that they had done that in this case, and therefore they couldn't be overturned. It doesn't appear as though the Upper Tribunal accepted the argument, the statutory construction argument that the taxpayer was putting forward, which was essentially in every case you have to look at the whole of the exchange, because the exchange has to form, this is the form part of argument. What they seem to be saying is that it's a question of fact in each case for the tribunal to decide what is the relevant transaction. And they could have decided in this case that the relevant arrangements were what we said, and that would have been unassailable equally, because that would have been a decision on the facts. That seems to be the approach, as far as we can read it, of the Upper Tribunal. They weren't deciding as a question of, if you like, of law, that in every case you have to look at the wider transaction. They have to look at the purposes of the commercial purposes of the exchange. Now, it's quite important, but obviously to the revenue and to taxpayers, that we know what the test is, how it should be applied. Taxpayers need to know, but also the revenue, particularly because they have to give clearances, as we've seen. So they have to know how they're going to apply the legislation when a taxpayer comes to them and says, this has happened, we want you to confirm that we don't fall within section 137. So we need to know precisely how it should be approached. And in my submission, it's just not an acceptable or sensible approach to say that it's a question of fact in each case for the first tier tribunal. There must be a much more analytical approach. We also, of course, I've already made my submission, we say that's directly contrary to the structure of the provisions. But it's not surprising that it is, because that would be a very unusual provision that allowed a wide-ranging decision of fact.
If it's right, Mr. Hewitt, as said in Cole, that the revenue does not have to identify a scheme or arrangement of which it claims tax avoidance was a main purpose, how does it work, if you're right?
I certainly agree, my lord. That's a very strange way of putting it. I mean, the more important part is that the taxpayer has to prove there is none, which is the next part. The practical answer to that, of course, is in every case that's going to come before the tribunals, the revenue will be putting forward, inevitably, what they say is the scheme or arrangements. I think the point that the Upper Tribunal were really making was that the taxpayer has to prove that that is not, and it has to prove, really, disprove all of the possible, or establish that all of them are. This goes back to the point, it's not a question of determining, as a matter of fact, which is the appropriate arrangements to look at on some kind of airy-fairy kind of idea of what is appropriate. And be a question of fact for the tribunal in each case. The way the provision works, we say, is that you have to determine, is there a scheme or arrangement? Is it the main purpose to avoid tax? Is the exchange, does exchange form part of it? And that's it. And the fact that you can find another lot of arrangements which the exchange form parts, where there's a different answer to the main purpose test, we would say doesn't help the taxpayer, because it doesn't satisfy the statutory provisions, which are worded in a way that you start with the proposition that section 135 doesn't apply, if you remember, unless, so the starting point is that it doesn't apply. It's a very slightly unusual provision, but it starts that way, unless you can establish 1 and 2, 1 being the exchange has for bona fide commercial reasons, and 2, it didn't form part of a scheme of arrangement. So you have to establish both of these things in order to be within section 137, which one has to remember is a relief. I mean, where I started in all of this is that in principle these are disposals for consideration and are chargeable to capital gains tax. So that this is a specific relief that is being given. under section 135. So one doesn't start from the proposition that you're entitled to the relief. One starts from the proposition that you're not entitled unless you can bring yourself within the provision, in my submission.
Okay.
That's the way it's all
I think
structured.
you're beginning to trespass on Mr. Pross.
I think I'm sorry, Mal. I've finished. I wasn't intending to take this long, but I think
Well, thank you. Anyway, it's been
a lot to say.
very helpful to hear Paul's
I've
submission.
dealt with the respondent's notice point and while we're going along in relation to tax avoidance, so I'll say whatever I have to say in reply.
Yes, okay. Mr. Pross.
Yes, thank you. May I start by making submissions about the interpretation of the expression, the exchange in question, in section 1371? I submit in short that refers to the entire exchange, not to a part or an aspect of it. And if I refer to a part,
That doesn't seem to be in contention.
well, it doesn't seem to be in contention, but then when Mr. Ewart identifies a scheme or arrangements in my submission, he's focusing on an aspect of the exchange, namely the issuing of preference shares as an alternative.
Well, except I asked him directly whether he said the exchange under Lim 2 included the whole exchange, and he said it did.
Well, he said it did.
If he doesn't agree with that, he better jump now. Up, not,
Well,
not out of
he's-
a window or anything.
He said it did, but it's part of my case.
Right.
But at the same time as saying that it did, he then said something inconsistent with that, which is that he was entitled to identify as a candidate scheme, a scheme which related to an aspect only of the exchange. So in my submission, there's a fundamental
Well,
inconsistency.
you know his argument now, which is not that it relates to a part of the exchange, but that the meaning of the exchange, the whole exchange, is qualitatively quite different from the meaning of scheme or arrangement. And the scheme or the exchange is simply the shares that are exchanged, and the scheme or arrangement includes intentions, plans, and tax avoidance proposals. Yeah. So that's different, he says.
Well, he says it's different, but there is nevertheless a relationship in the legislation itself between the exchange and the scheme or arrangements, namely that the exchange must form part of.
Well, that's your point, yes.
Well, that is one of my points.
Yeah.
That's the size does matter point.
Size matters.
Yes, size matters in the sense that to say that one thing is part of another does mean, in my submission, it means that the latter consists of something more than, in this case, the exchange. That is the natural meaning of the words form part of. But before I understand the point that Mr. Ewart accepts what the exchange means. Nevertheless, could I just make one extra point? And this is by analogy with the Cole case that we've seen. And Lord Justice Snowden said, what if you've got a number of shareholders, some of whom, let's say they're all over 5%, some of whom are completely unaware of Mr. Big's plan to go non-resident. What then? Now, there's no doubt that the exchange means the composite exchange involving all of the shareholders and all of their shares. What Mr. Ewart's argument leads to is that the revenue can identify a scheme or arrangement relating to part of that exchange, namely Mr. Big's part of that exchange, and, as it were, infect all of the other innocent participants in the exchange. Now, I think he took that one on the chin, as it were. It's no answer to say, well, there's that 5% let out. Now, my submission is that if, on the other hand, one focuses on the entire exchange and asks whether the entire exchange forms part of the scheme, the answer to that would be no. Or at least not necessarily. Because then one would have to ask, in relation to the entire exchange, the significance of Mr. Big's involvement, as it were. In other words, that may or may not infect everybody else. It depends on how important it was to the overall scheme. It may be that the answer is that the other individuals are simply not part of that scheme or arrangements, and therefore they can say that the overall scheme did not form, sorry, the overall exchange did not form part of Mr. Big's scheme.
Can I ask you this? If you have an exchange of ordinary shares or ordinary shares and preference shares,
Yeah.
and the exchange is the whole of that, why can you not say in normal English that that exchange forms part of a scheme whereby the preference shares were specifically agreed in order to save tax by intention to sell a year's time and a year ahead, because you have a sort of Venn diagram where there is an overlap between the exchange, which is this big, and the scheme, which is overlapping. You know those little diagrams,
Yes.
and the middle bit, the middle crescent, is the overlap. So it's reasonable to say it forms part.
Well,
why is that wrong?
I'm not suggesting that is wrong. My submission is that if one is asking whether the entire exchange forms part of a scheme, one has to look at the arrangements as respects all aspects of the exchange.
Well, no, but that's what I'm asking you, really. We accept the entire exchange. The exchange means the entire exchange. But why can't the entire exchange form part of the entire scheme when there is that overlap? So there is part of the entire exchange that doesn't, but part that does, and part of the scheme that does, and part that doesn't.
Well,
Because there is definitely the latter on Mr. Hewitt's case. So there is a part of the scheme which is nothing to do with the exchange. In other words, the intention to sell later and blah, blah.
certainly the scheme is wider than the exchange. We agreed that far. But my submission is that if one's looking at a Venn diagram where parts of the exchange overlap with a scheme, that is the wrong example or analogy, because it is the entire exchange that one has to say is part of arrangements, and therefore you would look not only at the arrangements relating in this case to the preference shares, but also the arrangements relating to the ordinary shares, what the plans were in relation to both. And that would qualify as arrangements of which the entire exchange forms part.
So do you say it's possible but unnatural?
Well, I think there's a case called Wilkinson where the Revenue put the point this way. They said Russia is part of Europe.
Yes, that's right.
Yep. And if that's the point which my lord is making, the answer which the tribunal gave was, well, actually, no, part of Russia is part of Europe because a lot of it is in Asia. My submission is that when the well, in any event, it seems that HMRC are not suggesting that the exchange means part of the exchange. If we're agreed that far, it is the entire exchange. You cannot then identify part of the exchange overlapping with a scheme or arrangement. That is inconsistent with
Well,
saying
that's what
that,
I'm putting to you, is that it's not, because of the Venn diagrams where the two circles overlap.
Right.
And I think the answer has to be it's possible, but it's not the most natural construction.
No, it's not the most natural construction. If I could briefly go back to section 135, or at least refer you to it anyway, because what that says, as we've seen in fact, is that the exchange is deemed to be a reorganisation of a single company's share capital. But that includes the ordinary shares in this case that have been issued, as well as the preference shares. It's all of them which are encompassed in this deemed reorganisation of share capital. And then in my submission that follows through to 137, which is also focusing on all aspects of the exchange, not merely part of it, and asking a question about the entire exchange, namely whether it forms part of a scheme or arrangements. And therefore it is not only an unnatural use of language, but also inconsistent with the scheme of the legislation, to then focus on an aspect of the exchange and ask questions about that. that's my first submission, but it does, in my submission, gain power from the coral example, because it would be very strange indeed if HMRC could necessarily say, without a wider inquiry into the overall purposes of the exchange and so on, that just because one of the participants in the exchange had a nefarious purpose, that necessarily means that none of the participants qualify under Section 135. And that is the consequence, because our case is similar. We've got a single taxpayer that got 2 lots of shares, but one could easily see the same point applies to a number of shareholders who each of them get shares. One of them is involved in a scheme. Then on the revenues argument, that's good enough because they've identified that scheme relating to that taxpayer, even though that is only a scheme relating to part of the exchange. So that's my first submission.
Can I just
Yes.
try with you the point I put to Mr. Ewart, which is, although we've been talking thus far about it being common ground, you take into account at stage 1 the whole of the exchange. In fact, I think where Mr. Ewart ended up is, in a sense, you don't take account of the whole of the exchange, in the sense you ignore the precise terms on which the shares were issued. Your inquiry at stage 1 is actually a broader or less refined test.
Do you mean by stage 1 the bona fide commercial reason?
Correct.
Yes.
And because I put to Mr. Ewart that at stage 1 you should be actually looking at the individual terms of the preference shares. And if you reach the conclusion that those terms were arrived at for genuine commercial reasons, then it's difficult to see how at some later stage you could turn around and say, yes, but they have a tax avoidance purpose at stage 2. And
Yes.
Mr. Ewart's answer, I think, was that at stage 1, the scope of the inquiry doesn't require you to go down and look at in a granular way at the terms of the exchange. It's just a more general,
Value and identity.
well,
Maybe not
maybe
identity.
not even
maybe not
value, in fact, but just basically, is this a third? Is it an arm's length or
Yes.
some sort of other type test?
Yes.
Do you agree?
Well, I certainly don't agree with, given that we're now in the Court of Appeal rather than a tribunal of equivalent standing to Sir Andrew Morritt sitting in the High Court, that the inquiry is as limited as that at stage 1 and doesn't include looking at the terms. So but I would make 2 points in addition to that, if I may. The first is, the first stage isn't asking whether it's for bona fide commercial reasons only, so that you may satisfy the first test, even if there are other reasons as well for the exchange. And therefore, the fact that you've passed the first test doesn't necessarily tell you a great deal about whether you're going to satisfy the second test, when you look more widely beyond the exchange. But then my second submission is, unfortunately, I don't think I can rely upon the point which my Lord is making in the facts of this case, because it wasn't simply that the preference shares were automatically redeemable according to their terms.
They weren't automatically redeemable.
I beg your pardon?
Yes, that's right. They weren't automatically redeemable.
We had to do something,
certain notice.
and therefore it wasn't simply the terms that operated, it was a giving of notice. And therefore, if one's looking at a scheme or arrangements which is wider than the terms of the exchange itself, I have to accept that there was more to it than the terms themselves. And therefore, I don't believe I can rely upon the fact that we satisfied the first test as it were, necessarily meaning why shouldn't we satisfy the second?
But I think you do say that at stage 1, the inquiry can look at the terms. So let's postulate the example of somebody accepting at stage 1 prefs which are automatically redeemable on a certain date,
Yeah.
or redeemed by unless notice is given to the contrary, let's say.
Yeah.
If the view is taken at stage one that is for those terms are included for genuine commercial reasons, if there's nothing more than the carrying into effect of that transaction as constituted by the exchange,
Yes.
there would be no wider scheme or arrangement.
Quite. It's difficult to see.
I would agree with that. I don't
Right, well,
premise
Mr. Ewart
that they put
agrees.
forward.
Right.
If they were there for general commercial reasons.
No, I'm trying. Sorry, I'm trying to understand. I know Mr. Ewart doesn't put his case in this way.
No.
We won't agree with it.
No.
I'm just trying to understand
Yes.
what you say the
Exactly.
correct
Yes.
approach to the first
Yes.
stage of the inquiry
Yes.
is.
Well, I would submit that if all there was to it was aspects of the exchange and nothing else, such that, for example, as you've suggested, the redeemable shares are automatically redeemed in accordance with their terms, it's difficult to see what the wider scheme or arrangement could be, how the exchange could form part of something wider.
And so if the revenue were going to attack it, because they didn't like the tax result, they'd have to attack it at stage one on that basis.
Yes, they would. The legislation could have said, and is not and does not form part of. In other words, it could focus, stage two could focus on the exchange itself and on whether it forms part of something wider, but it doesn't. It only asks whether it forms part of something wider, so that in the example my Lord has given, it would be difficult to see what the wider thing is if there's nothing else going on, if there's no plan other than simply sitting there and waiting for redemption. Clearly, in principle, the two tests are looking at different things in the sense that the first is looking at the exchange,
Yep.
and the second is roving more widely.
But to take my Lord's point, if the Venn diagram is such that the exchange and the terms of the exchange are exactly coincident
Yes.
with what subsequently happens,
Yes.
which could be said to be the scheme or arrangement,
Yes.
in other words, there is nothing else,
Yes.
then, as a matter of fact, on those particular facts, you're looking
Yes.
at the same thing.
Yes. And, I mean, then the question would arise in relation to the first test. Is it enough to show that there were bona fide commercial reasons, even though there are also tax reasons? But as I've submitted, the first test doesn't say exclusively bona fide commercial reasons. So I'm not sure what the outcome would be in the example you've given. So then, if one applies my submissions in relation to this first point, to the facts of this case, the exchange in question consists of the issue of the ordinary as well as the preference shares and the transfer of the CDL shares. And therefore, the focus of the second test should be on whether that exchange, those elements, all of them, formed part of a scheme or arrangement. Now, my second set of submissions then is to do with the interpretation of the words does not form part of a scheme or arrangements. I think I've made my submission on the meaning of form part of, that it is looking at something wider than the exchange itself.
It does say A.
Yes, does not form part of a scheme or arrangements.
Indicating there could be more than one.
Yes, and of course, in principle, there could be more than one. My submission is that it is for the fact-finding tribunal, first of all, to ask, does the exchange form part of a scheme or arrangements? Just stopping there, and if so, what is it? What does the scheme or arrangements consist of or comprise? And that is before going on to ask a question about that scheme or those arrangements, namely, what its purpose or purposes are.
Main purpose.
Or, I beg your pardon, main purpose or main purposes are. And that, I would submit, is as my Lord put it before the short adjournment, the cart before the horse point. That you must consider, identify whether there is a scheme or arrangement of which the exchange forms part, and if so, what it is, before going on to ask the tax avoidance question about that scheme or arrangements. Whereas, what HMRC are doing is saying we have been able to identify a tax scheme here, and it involves the decision to ask for prefs instead of cash. That is the wrong approach, in my submission, partly because, as I've already submitted, it involves focusing on part of the exchange, but also because it's, as it were, too early on in the inquiry. And my submission in relation to does the exchange form part of a scheme or arrangements, and if so, what are they, is a question of fact.
But why does it have to be done seriation, to use a Latin expression I hate? Why does it have to be done in that rigid order? Because it says part of a scheme or arrangement of which the main purpose is tax avoidance. So why should you not construe scheme of or arrangements, the main purpose of which is tax avoidance, so that you're looking for, when you're a fact-finding tribunal, a scheme or arrangement which has a main purpose of tax avoidance?
Well, one answer, but obviously not a very good one at this level, is that that's what Sir Andrew Morritt said that the tribunal should do in the Snell case.
We have huge respect for Sir Andrew Morritt.
Yes. But that's, if I can show you, perhaps
He
you've
didn't
seen
have
the-
argument like this, by the way.
I beg your pardon?
He didn't have argument like this.
No.
I don't mean he had Mr. Ewart, but I don't mean that. I mean he didn't have an argument on these points.
No, absolutely. And going back to the facts of Snell and Collin, saying, well, those points weren't argued, is not in my submission a good point to make, because the judges in those cases can only deal with the issues raised before them. But in any event, he, before descending into the facts of the case, did say that there are two issues of fact here. One is, did the exchange form part of a scheme or arrangements? And if so, what was it, or what were they? And then the second one is, if so, did that scheme or arrangements have as a main purpose, or one of its main purposes, the avoidance of liability to tax? Now that is the approach which the FTT adopted in this case. It divided up the inquiry in that way. Now that's one answer then, that Sir Andrew Morritt said so. The other in my submission is that it avoids confusion, because if you immediately look around for a tax avoidance purpose, there is a danger, which in my submission HMRC have succumbed to here, of identifying arrangements relating to part only of the exchange. So if you keep the inquiry separate in the way I've suggested, and you say, right, I've got to ask whether the exchange forms part of a scheme or arrangements, I'm not going to sort of prejudice my inquiry by hunting around for a tax purpose here. I'm just going to ask a neutral question.
But Cole said it's not incumbent on the revenue to state what is the purpose,
Yes, absolutely.
is the scheme.
No, it's for the taxpayer to prove on the balance of probabilities that the exchange did not form part of, or was done for, effected for bona fide commercial reasons, and did not form part of the scheme. I accept that the burden of proof is on the taxpayer, but that, in my submission, does not alter the nature of the inquiry for the tribunal. In other words, the fact-finding tribunal is still going to ask itself, okay, has the taxpayer proved his case? But a case about what? Whether the exchange forms part of a scheme or arrangement, first of all. And if so, what is the purpose or the main?
Don't they have to prove, I mean, doesn't the taxpayer in common parlance have to prove that the exchange does not form part of a scheme which has as its main purpose, or a main purpose, tax avoidance.
Yes.
They have to prove the whole thing. I mean, saying they have to prove it doesn't form part of a scheme is a bit meaningless. Well, what sort of scheme?
Right. Then I've misstated, and I apologise. What the taxpayer needs to do in my submission is to first identify whether the exchange does form part of a scheme or arrangements, and then...
With the main purpose tax avoidance.
Well, okay. But then say something about it not, that scheme or arrangements not having as a main purpose the avoidance of tax. Now, I submit that's what was done below, it happens by me, by identifying a scheme or arrangements of which the entire exchange formed part, namely arrangements relating to not merely the issuing to the company of the ordinary shares, but the decision to hold on to those shares for a substantial period of time in the expectation that they would enormously grow in value and they would give the company an opportunity to make a takeover bid. So that was the financial and strategic advantages that were sought in not merely having the shares issued to them, the ordinary shares, but also holding on to them. And I accepted there was also another aspect to the arrangements of which the entire exchange formed part, namely the issuing of the preference shares and the holding on to those preference shares for 12 months with a view to redeeming them and claiming the exemption. Now that was the scheme or arrangements which I identified, and the reason why the tribunal accepted that, as opposed to HMRC's narrower scheme, was twofold. First of all, the terms of the legislation, which required the tribunal had accepted to focus on a scheme or arrangements of which the entire exchange formed part, and it thought that the revenues focus exclusively on why the preference shares were issued didn't satisfy that test. But also the tribunal said that it would be divorced from reality to, as it were, salami slice the arrangements into separate arrangements relating to the ordinary shares and the preference shares. So that deals with HMRC's point that they had been able to identify a scheme or arrangements which had as a main purpose tax avoidance, because the tribunal said no, it will be divorced from reality to regard that as a scheme in its own, or arrangements in its own right. There was a wider scheme or arrangements which, as a matter of reality, comprised the commercial holding onto of the ordinary shares, as well as the tax-driven issuing and holding onto the preference shares. So that was a finding of fact about the reality of the arrangements. It wasn't simply picking and choosing between which arrangement, in some airy-fairy way, as Mr. Ewart put it, seemed more appropriate. It was only appropriate, as the tribunal put it, because that reflected the reality of the matter. I mean, the concept of arrangements involves doing something for a purpose. Having shares issued to you and then holding on to them, there was an overall purpose. That's what the tribunal found as a fact, which comprised all those elements. And there's nothing wrong, there's no error of law in that finding of fact in my submission.
I mean, effectively what you're saying is that in order for the revenue to thread themselves through the part of gateway, the scheme or arrangement which they would have had to identify is one that must have included the whole of the exchange.
Yes.
And once you get there, you have to ask the question about whether the purposes of the whole of the scheme or arrangement thus identified were tax avoidance, to identify whether it's the main or...
Yes, one of the main purposes. Yes.
And you say it's there that the revenue have gone wrong because they didn't identify the wider scheme of arrangements of which the whole of the exchange could form part.
Yes.
It's in getting through the gateway that they went wrong.
It's partly that point, which, as the tribunal put it, was in accordance with the section, but also it said because it would be divorced from reality to regard the plan in relation to the preference shares as a scheme or arrangements in isolation from everything else. There was...
So can I ask you this?
Yes.
If the scheme were reversed,
Yep.
so that the ordinary shares were 10%
Yep.
and the preference shares were 90%,
Yep.
but the facts were otherwise the same,
Yep.
how does the entire exchange form part of a tax avoidance scheme?
Well,
Because
it can,
because the 10% does not.
well, the 10% does not. The tribunal in this case found that both aspects, the ordinary shares and the preference shares, formed part of the same scheme or arrangements. The reason why it said that the tax part to do with the preference shares was not one of the main purposes was a number of factors, including the amount of tax being saved relative to the value of the scheme as a whole and so on. If the facts were reversed, as your lordship suggests, it would be very easy for the tribunal to say, yes, there's one overall scheme here. It does comprise a number of elements, but the tax saving part of the scheme is sufficiently important to be a main purpose.
90%.
No, but I'm sorry, you're not tackling my question.
Right, I
head on,
apologise.
I'm afraid,
Yep.
because the part of your argument, which I regard as quite an important part, is that the whole exchange is the whole exchange, and the whole exchange has to form part of a wider scheme, namely the whole exchange plus some intentions and timing issues and things that you intend to do, a plan
Yep.
to do to
Yep.
avoid tax,
Yep.
right? And you say it's not the whole exchange, it's only a part of the exchange that is part of that wider plan, right? Therefore, it doesn't come within the statute.
No, with respect. I don't know whether my Lord Justice Snowden wants to
You
answer
answer
that.
it,
Yes.
he can answer it here for himself.
Okay. Well, what HMRC is saying is we've identified a scheme or arrangements here, namely that part of the exchange relating to the issuing of the preference shares and then the holding of them with a view to redeeming.
Yes.
Now that fails the test of looking at the entire exchange. It also failed the test according to the FTT that as a matter of reality, that plan was part of wider arrangements, part of a wider arrangement on the part of, or scheme on the part of the company, that also comprised their plans relating to the ordinary shares. So they had plans, and that was an overall plan relating to both. Now, if we reverse the facts, as you've suggested, and we have 90% attributable to the press, the tribunal, if it was adopting the same factual approach as here, would say, yes, look at the overall plan. It has a number of purposes, one of which is commercial, but a very important part, namely 90%, is to do with tax. And therefore, one of the main purposes is tax avoidance. Leaving aside the avoidance part, one of the main purposes is to do with tax. Now, the fact that the legislation talks about one of the main purposes, in my submission, shows that it's looking at arrangements which could have a number of purposes, a number of subsidiary purposes, a number of main purposes. That's the possibility anyway. And it's for the tribunal.
I mean, I get all that.
Right.
I completely
Let me just
understand
finish
all
the point
that.
then.
And I have read the FTT decision and paragraph 72, whatever it is. But my point is that the scheme identified by the revenue here is a scheme which does not include the exchange of ordinary shares for ordinary shares.
Yes.
Right?
Yes.
So, if in my reversal of the facts, the revenue would presumably identify a scheme which did not involve the exchange of ordinary shares for ordinary shares.
Okay.
And do you say, I mean, you say that's the wrong approach because you have to take the whole scheme, but actually you have to take the whole exchange, but actually the scheme they're identifying, and it's for them to say we're trying to prove our case, or to show there is a scheme, doesn't include the whole exchange either way.
Well, maybe it comes back to the meaning of scheme, and what Sir Andrew Morritt said is that a scheme involves a plan with some overall purpose or purposes.
Sure.
And what I would submit HMRC are doing is picking out an aspect of an overall plan.
But I'm on form part of, you see. That's what I'm addressing here. I mean, I quite get all that about the overall, the other aspects of it, the qualitative difference and blah, blah, blah.
Right.
But I'm on form part of, because to me, form part of is a very significant part of your argument.
Yep.
That the words require, the words of the statute require the entire scheme, because that's what it means.
Yep.
Sorry, the entire exchange.
Yep.
Confusing myself.
Yep.
The entire exchange to
Yep.
form part of the scheme, whatever that scheme
A
is.
scheme, any scheme.
A scheme.
And it's for the taxpayer to prove in relation to all those possible schemes that actually existed that none of them had a main tax avoidance purpose.
And my question is, if I'm wrong about my Venn diagram I put to you earlier, which I understand your answer to, how can the entire exchange be part of a scheme unless there's something wrong about the ordinary share exchange?
Well, that is my case. It can't. I mean, that
Then
might be
that's
a question
very,
you put to
very
Mr.
narrow
York.
provision.
No, it's not a very narrow provision because there are lots of possibilities of the tribunal saying, well, yes, there's an overall arrangement here of which the whole exchange forms part, and it has a number of purposes. And exactly in this case, the tribunal said that and weighed them up and found that tax wasn't one of the main purposes. So that there is, it isn't narrow. My interpretation involves taking a wide view and then leaving it to the tribunal, the fact-finding tribunal, to weigh up, to identify and then weigh up the importance of the various purposes that those identified arrangements have. That isn't taking a narrow view at all, because if it were the case that tax was of more importance than Euromoney was able to prove, then it would have been held that Section 137 applied. But that is simply, in my submission, the natural reading of the legislation and then a factual inquiry, which is down to the fact-finding tribunal as to what the purposes were of that overall scheme or arrangements and how important, if at all, tax was to it. Whereas HMRC's inquiry is a much narrower one, much narrower than mine, because it involves looking at a part of the exchange which you've identified because that's the tax-driven bit, and focusing exclusively on that and ignoring all of the commercial purposes that the exchange was entered into for. My submission is that HMRC's is much narrower. And
can I just run it this way and see if
Yep.
this lands well or not?
Okay.
When we look at the first, well, the subject of the provision is the exchange in question.
Yep.
That's a unitary concept. There's
Yep.
one exchange. It might have several component parts, but one exchange.
Yep.
Is it your submission that there's one exchange that you look at as the subject of the bona fide commercial reasons, and then there's one exchange that you look at thinking about whether it's part of a set of arrangements, one set
Yes.
of arrangements. There's one thing on each
It's
side.
the same thing that each
And
of
where
those
they
tests
go
is.
wrong is that they look at a subset of exchange and a scheme within a set of arrangements, a subset of arrangements, and they can fiddle with the subset of arrangements, you'd say, to make it fit the case they want to get to.
Yes,
Something
absolutely.
like that.
And that is always going to be the case, yes. But that is always going to be the case if you have any exchange which involves a tax element to it, that it's always possible to focus exclusively on that element and say that is a scheme in its own right, and therefore that which has maybe a sole tax purpose. Indeed, it's difficult to see where one of the main purposes can ever operate if you're going to be able, as the revenue would like you to do, drill into an aspect of the exchange which is there for tax reasons only. Where does all this, one of the main purposes, ever fit in? In my submission...
Well, because it's one of the main purposes of the scheme, not one of the main purposes of the exchange.
Well, but, okay, so I come back to the point that the exchange has to form part of the scheme.
Well, I
And
completely get that.
just to suggest we've identified an exchange. Let's forget about that now. Now let's ask whether there's a scheme. Is not what the legislation is asking you to do. It's expressly requiring you to identify a scheme of which the exchange forms part, and therefore you cannot move away from looking at the entire exchange, just as you do in relation to Lim 1 or Test 1.
So it's really asking you to answer the simple question. I'm not sure it even needs breaking down. Is the entire exchange, does the entire exchange form part of a scheme or arrangement of which the dominant purpose is tax evasion?
One of the main purposes, yes.
Yeah.
Yes. That's what it says.
Yeah, that's what it says.
And it's as simple as that. And in my submission, the reason we haven't had this sort of case before is because the revenue haven't thought of this point before, which is let's drill down at a particular aspect of the exchange and ask questions about that and the scheme it forms part of.
You see, I think that's a false, analysis of their case. They avowedly say that it is the whole exchange and that the whole exchange is part of, can be properly semantically regarded as part of their scheme, which is different but contains, actually only focuses on a part of the exchange. So they say, they take that on board and say that it can be that.
In my submission, they may be saying they're taking it on board, but if one spells it out, how can it sensibly, as a matter of ordinary English, be said that the entire exchange forms part of something which is to do with a small part only of the exchange? Well, in my submission, that is not
a big part. That was what
it might be a big part. It might be a big part, but nevertheless, if the scheme or arrangement is focusing on a part, whether big or small, of the exchange, then the inquiry has gone wrong, because the exchange, the entire exchange, must form part.
Well, you see, that's my. I still don't completely get your answer to that, because if it is a big part, then it is the same as being a small part. If you say it has to be the entirety of the exchange, and the scheme doesn't actually affect a part of it, then it's not the entirety of the exchange forming part, it's a part of the exchange forming part.
Well, but if you're suggesting that that is a sort of loophole for the taxpayer to exploit by saying, oh no, it was only a part of the exchange which forms part of my scheme, I would submit there is no way in which
because it wouldn't be dominant purpose then, you wouldn't be main purpose, but I mean that's the other way out.
Well, my submission is that you would focus on the entire exchange. You would say, does the entire exchange form part of a scheme or arrangements? And you would then look, or might look, depending on the facts, at the intentions and plans relating to all aspects of the exchange. And it wouldn't be an answer in my submission for the taxpayer to say, no, you can't look at my tax avoidance plans because they only affected a part of the exchange. If that's the point which my lord is making, because the answer to that would be, but I'm going to look at the entire exchange and see that the plans you had for the entire exchange, and a large part of those plans related to what you were doing in relation to the preference shares in this case. And if they formed a large part, then there would be an answer. And it wouldn't be possible for the taxpayer to say, no, you can't look at my plans in relation to the preference shares, because that only relates to part of the exchange. We're looking at that as well as the plans relating to the ordinary shares. And then we're weighing up the purposes, by reference to their importance, to see which are main and which aren't. So that there isn't going to be a loophole here of the taxpayer being able to say, unless my tax avoidance actually relates to the entire exchange, you cannot catch me. That would not be open in my submission to the taxpayer, because it's always possible for the tribunal to say that the entire exchange, all aspects of it, formed part of a single scheme.
I mean, this exchange, I think, is touches on the example you give in your skeleton argument, I think, but as I understand the argument, your argument, it runs like this. Assume a vendor reaches an agreement, broadly speaking, valuing the shares that they're going to sell at 100. And this particular vendor says, I'll have 90, please, in ordinary shares and 10 in redeemable preference shares. That's, now the exchange is the whole of that arrangement. So the agreement is then signed. It's for 90 prefs. Sorry, let's get that the wrong way around. I can't remember which way around I started.
90 orders, 10 prefs.
90 orders, 10 prefs.
Yeah.
And that's the entire exchange. You then go through the gateway and you say, first of all, is that for genuine commercial reasons? Answer yes, because otherwise it would fail right at the start. It's at arm's length. You then go through the gateway and you say, okay, is there a scheme or arrangement of which that entire exchange forms part? And you would say yes, because there's a scheme, at least in relation to the 10% of prefs, that involves exercising the right to redeem the prefs in more than a year's time and claiming a tax relief. And so for the tribunal, there will then be the question, does that tax avoidance, assuming it is, part is that a main or one of the main purposes for the scheme or arrangement as a whole, and where the number of preference shares is limited to 10%, but there's a very good other reason why the rest of the transaction was put together, and for the 90% of the ordinaries and the investment element of it and everything else, the tribunal could conclude, okay, there was a tax avoidance element, but it's not one of the main reasons for the transaction.
Yes.
If you reverse the numbers and say, actually, when asked, the vendor says, no, I want 10% in ordinaries, but 90% in redeemable prefs, and you go through the same equation, it's possible the tribunal may still buy it, but it's much more likely the tribunal will just say, come off it.
Yes.
Your tax avoidance element was undoubtedly the main part.
A main. It only has to be a main.
A main.
Yeah.
Because, it's just obvious it's 90%.
Or even if it's 50-50.
You asked for it in that way, but that would be an evaluative. It's actually an evaluative judgment.
It's
not
left
it's not a fact finding as such. It's an evaluative decision as to what the main or a main.
It's not primary fact.
Part. But what you say is critical is you can't salami slice up the exchange at the second stage. You must take the whole of the exchange into your evaluative exercise at stage 2.
Just in case I haven't properly responded to the Master of the Rolls, I submit that it would not be possible for the taxpayer in that example of, let's say, where it's 90 prefs and 10 ords, to say, you haven't identified a scheme or arrangements which applies to the entire exchange when you focus on the prefs, because you've also got to focus on the ords. Yeah. But the answer is we do focus on both.
Yeah. As long as you've taken the entire exchange into your scheme or arrangement to test it at stage 2, that's fine. What you say the revenue are doing wrong is they've picked out a little bit of the exchange and are testing it at stage 2 and saying, oh, surprise, surprise, we have a tax avoidance, and almost by definition it must be the main one, because we've just salami sliced out the relevant bit which we like the look of.
That's my submission. Yeah. But it may not satisfy my Lord, the Master of the Rolls, but I do want to make sure, not that I'm satisfying, but that I've given you the best answer I can.
No, we're having a lot of talk about salami, I'm sorry. That's fine.
Very keen on salami, the Master of the Rolls.
Well, however one expresses it, my submission is HMRC have focused on one part to the exclusion of the rest, and therefore satisfied themselves that they've identified something with the appropriate main purpose.
Well, your main purpose argument helps you. If you look at it in the holistic way that I suggested to you, then you can say that the main purpose solves the problem of having the entire exchange within the scheme. It's only if you dissect it or salami slice it to take the main purpose into a third stage of a process that you could be said to fall into the part of problem that I put to you at the beginning.
We don't want the salami to be even more processed than it is, I would submit. But yes, absolutely. And
are you going to address the consequences of the revenues construction?
well, I've addressed it partly in my skeleton with the perhaps silly example of £10 million worth of ordinaries and £1,000 worth of prefs. But although that might be regarded as an unlikely example, nevertheless, in principle, it tests the point. Namely, can it really be that Parliament intended that something which admittedly has a tax avoidance purpose, but which in the overall arrangement as far as the taxpayer is concerned is very, very unimportant, should nevertheless have the result of disqualifying the entire exchange from relief?
Well, he says it can, partly because main purpose might not be satisfied, might or might not, depending on the way it was structured, and secondly, because the whole purpose of this is to strike down anybody who tries to avoid tax.
Yes, at all.
At
And
all.
my submission is that there would be more force in his argument if the legislation said sole purpose, for example, because then one would say, well, that must be looking at an aspect of it rather than at overall. But given that it's one of the main purposes, my submission is that that indicates that one's looking at something more widely than an aspect, a tax-driven aspect of the exchange. It's not a powerful point in itself, but in terms of consequences, the other point is the coal point, that why should one taxpayer who knows nothing about the avoidance be stymied, as it were, because of another taxpayer's avoidance plans? And necessarily, in other words, it's not a question even of the tribunal weighing up the facts in relation to that taxpayer. It's simply, inevitably, because HMRC have been able to identify a scheme in relation to one taxpayer, that necessarily means that all the other taxpayers fail. And my submission is that would be a disproportionate result if it were necessarily the case.
No, but if you're talking about the whole scheme, I mean, if you're right about your construction of a scheme or arrangement has to be the whole scheme, including the whole exchange, then the fact that one taxpayer has a secret idea is not part of an overall scheme.
No. Well, that's my submission, but you're asking me to explain, I thought, or give submissions on the consequences of HMRC's interpretation. And HMRC's interpretation means that because Mr. Big has the tax avoidance purpose in relation to why he wants loan notes, let's say.
But they might be wrong, right?
What might be wrong?
They might be wrong about
Well,
that. They might be wrong, and in fact, their interpretation might give rise to the fact that Mr. Big's secret intention doesn't make any difference, even on their construction.
I find it difficult to see how that could be so, because HMRC would say, look at the exchange. There is included within that exchange something that Mr. Big is doing, and that is a scheme or arrangement in itself. So even on their own interpretation, I cannot see how it could be argued that the Mr. Big avoidance doesn't infect everybody else. But anyway, my submission is it would, and therefore that's a consequence.
You say what should happen is that the tribunal has to reach an evaluative decision as to whether, looking at the entirety of the exchange, including Mr. Big and all the underlings, if I can put it in that way, it could be said that Mr. Big's tax avoidance purpose was the main or a main purpose for the scheme as a whole.
Yes.
And it may be, depending on how important he is compared to everybody else, that the answer might be yes, they would be infected. But there would be a decent prospect, depending on the numbers, that actually they might all say, no, it isn't a main or the main purpose, the tax avoidance.
But there will be another, yes.
Whereas
is
you're
possible.
saying that the effect of the revenues interpretation is that they will always win,
Yes,
because they'll always just define their scheme and arrangement
yes,
to be exactly the extent of the Mr. Big tax avoidance purpose.
yes,
And if they define their scheme or arrangement that way, they win.
yes. But the inquiry I would submit on the part of the fact-finding tribunal would be, first of all, to decide whether the entire exchange forms part of a scheme or arrangement. And having done that, they might decide that the scheme or arrangements of which the exchange forms part is not a scheme or arrangements which includes Mr. Big's tax avoidance plans. They might conceivably be a separate scheme relating to him only, as opposed to one of which the entire exchange forms part. So, in any event, it's possible in my submission for the tribunal to perform its evaluative function, as it were, and ask questions about main purposes and the scheme, what scheme or arrangement there is, whereas on HMRC's interpretation, that would just be an automatic no. So that's my submission about that. And so, in a sense, HMRC's interpretation is almost saying we can't really trust the fact-finding tribunal to answer the question properly, to do that weighing up or evaluative exercise. And my submission is you can, and you should, and that's what Parliament has entrusted to the tribunal, to do that job. I don't think I need to make any more submissions about Snell and Cole, other than to say they're obviously facts far removed from the present case. No one was considering the questions which are being considered today, not because of a failure of advocacy, I would submit, although it said in HMRC's skeleton they were experienced and expert counsel, they would surely have thought of this point. The real answer is that the point wasn't open. It was a very simple case in relation to Mr. Snell. Mr. and Mrs. Cole was a bit more complicated because you had two taxpayers, but the facts found, we haven't got the FTT's decision in front of us, but the facts found by the FTT were that they were both party to the scheme.
I had picked up that there was a sense that they were both dishonest as well, that
Well,
they lied.
She had altered her diary in order to give the impression that there were commercial plans afoot and so on. But in any event, she was in it, as it were, whether dishonestly or not, as much as he was. And therefore, it just wouldn't have helped, really, to say, what about me? You know, weigh me up against my husband, kind of thing. That wouldn't have helped at all. So those cases really, what the judge in each case said was in the context of the facts before them, and just doesn't assist in my submission. Although I would, nevertheless, rely on Sir Andrew Moritz saying, this is the way you should approach it. These are the questions which are issues of fact which you should ask. I would regard that as helpful, because that wasn't driven by the facts of the particular case. That was just looking at the section.
And no doubt you rely on Mr. Hewitt's own submission that you had to look at the whole scheme.
Well, yes, absolutely. And in fact, it was common ground. So this brings me to the Brebner point. And this is the Brebner point. This was my failure before the FTT in inviting them to look at Brebner, which said look at the arrangements as a whole. I should have said look at Snell, which says look at the arrangements as a whole. Well, obviously, that was on point in terms of the legislation, so that was my fault. But I would submit the tribunal didn't go wrong anywhere. Mr. Hewitt says that's a major error. Well, actually, all the tribunal was saying effectively was, well, two things. First of all, I'm going to look at the scheme or arrangements as a whole. And it could have done that with the benefit of Snell, and that must be right anyway. The second thing it did was just to say there's a parallel here between that case and this case. In that in this case, I also think, as a matter of fact, it would be divorced from reality to salami slice the arrangements into those relating to the prefs and those relating to the awards. That wasn't driven by anything in Brebner. That was simply saying there's a factual parallel here.
Do you say that the revenues argument leads to uncertainty for the law as regards in this area?
Well, I suppose if you decided very clearly that the revenue were right, there would be certainty.
Well, there would be certainty as to what the statute meant if we did our job properly, But there would then be difficulty, would you say, in implementing it in particular cases until you'd exhausted massive amounts of disclosure and you'd looked at everything that happened in the process?
Well, I'm assuming that in any case that got to, obviously not to the stage of asking for clearance from HMRC, but got to the stage of the tribunal, there would be proper disclosure made, put it that way. And the tribunal wouldn't be concerned that things are being hidden and so on. But I would submit there could be uncertainty in the sense that you wouldn't necessarily know what the scheme or arrangement which HMRC were putting forward was and how to disprove that that was a scheme or arrangement of which the exchange formed part. You would be left in uncertainty, I would submit, as to whether that was indeed a proper description of the scheme or arrangements. But if you decided that, although Section 137 says the exchange must not form part of, nevertheless, it is possible to focus on an aspect of the exchange and ask whether that forms part of a scheme or arrangements. If that's what you decided, then I suppose there will be no uncertainty to that extent. But it would be, I simply repeat really, that's not a result, I would submit, which Parliament could have intended, given the disproportionate results that it would.
Can I ask you about the timing? I think I put to Mr. Ewart that he should be looking at the exchange that is ultimately agreed, not multifarious intermediate points at which different proposed transactions were negotiated.
Yes.
And he said his ultimate argument is it doesn't even matter if you don't have this email, I'm still right. What do you say about those two submissions?
I would think I would agree with them, because the question obviously is one that is focusing on the exchange and not negotiations leading to the exchange. But if one asks the question, what was the purpose, what was the role of the preference shares, and that is a relevant question to ask, which the tribunal did ask and answer, then one can see what that role was from the email.
From the
email.
Yeah.
But it's of evidential value rather than
Yes.
legal significance, is
Yes.
what you're saying.
Yes.
In other words, you always only ever look at the exchange which actually took place.
Yes.
For the purpose of testing it against Section 317.
Yes.
But the run-up to it, or indeed what people might have said about it afterwards,
Yes.
is just part of the evidence by which you can discern
Yes.
what the reasons were or the purpose
Yes.
was.
Yes. There was a debate in the Upper Tribunal where HMRC seemed to be saying it was swapping preference shares for cash. And the Upper Tribunal was concerned about that because that wasn't the exchange. It didn't involve swapping, having shares instead of cash. But I think what it came down to was HMRC was saying that's to do with evidencing why the preference shares were there. And I wouldn't criticise
No,
that.
you say exchange is what happens in the end, and scheme may well be, there may be relevant evidence in the run-up to the exchange that is relevant to what is the scheme.
Yep.
So really there isn't much between you about the difference in the meaning of scheme and meaning of exchange, because you accept the scheme includes all the purpose and all the reasons and all everything else.
All the plans.
And the only really dispute between you is meaning of a part of.
Well, if you like to put it like that, I would still suggest that Mr.
Well, and
Ewart...
choosing the scheme.
Yes. Again, I wouldn't necessarily agree with the words choosing the scheme, as if there are a number of schemes which satisfy the legislative criteria and then one chooses between them. That's not what the FTT did here. What the FTT did was to say there was only one scheme which satisfied the legislative criteria, being a scheme of which the exchange formed part.
No, Mr. Ewart says you can choose the scheme if there is one that satisfies the purpose, and you say you have to look at the whole scheme.
Yes, there's not a question of choosing.
No, I understand.
And my only other quibble is that I still don't accept that Mr. Ewart really takes on board the force of the point that the exchange means the entire exchange. Because I cannot understand how, if one did take that fully on board and then ask whether it forms part of something, one could then go back to focusing on a part of the exchange. But that maybe you would, my lord, would say, well, that's to do with the meaning of form part of. But I just do not see how form part of can mean or part of which is.
But we have to evaluate the arguments as they're put, and Mr. Ewart has at no stage said to us that exchange means part of the exchange.
Well, I accept that, but I would submit he hasn't followed through the consequences of that admission.
Well, if you're right, then that's good for you, right?
Of course it is. Yeah, but I just want to make it clear what I do understand, where I'm submitting Hughes from wrong.
It's really quite a simple case.
Well, I thought it was. I thought it was before when I was in the FTT. Well, shall I come on to our respondent's notice?
Okay.
And the short point here is my submission is that the concept of avoidance of liability to tax in section 1371 has the meaning stated by Lord Nolan in the Willoughby case. In other words, it's not simply not having a liability to tax, it's more of an evaluative exercise than that. I need to take you to Willoughby, which is at tab 12 of the authorities book. If I can use the page numbering at the bottom, it's tab 12 and it's page 34 at the bottom. Now, at the bottom, indented is section 741 of the Taxes Act 1988. And it says section 739 and 740 shall not apply if. 739 and 740 are the tax charging provisions. I don't think I need to go into more detail than that. 739 was to do with someone who made a transfer of assets and income arises to a non-resident, but the taxpayer has power to enjoy that income. And 740 is to do with someone who's not involved in the transfer but receives a benefit as a result of that sort of transfer. So they're separate charging provisions. Anyway, they shall not apply if the individual shows either, and I'll concentrate on A, the purpose of avoiding liability to taxation was not the purpose or one of the purposes for which the transfer or associated operations or any of them were effected. And in the case of, I think it was Professor Willoughby, he had taken out an offshore bond, a form of insurance policy, which grew in value as a result of income arising to the non-resident insurance company. And HMRC sought to tax him on that income under section 739. He had power to enjoy the income because the bond was going up in value. And there was an argument about whether that constituted avoidance of liability to tax. Then if one goes to page 36, and I don't think I need to ask you to read the parts of it which are then applied by Lord Nolan to the facts of the case itself. It's simply the concept of tax avoidance. So picking up at B, in order to understand the line thus drawn, submitted Mr. Henderson, down to below G, which I accept. If I could ask you to read those two paragraphs.
Sorry, on page which?
Page 36 in the bundle. B to G. So that what is being said there is that we are familiar with the concept of tax avoidance as distinct from a different concept of tax mitigation, and that concept or that distinction owes much, it's said at E, to the speeches of Lord Templeman and Lord Gough in Ensign Tankers. Now, Ensign Tankers wasn't about section 739 or 740, and the concept of tax avoidance wasn't used in the legislation that Ensign Tankers was concerned with. Nevertheless, Lord Templeman and Lord Gough said something about what tax avoidance was as opposed to what tax mitigation was. Now, given that the passages are quoted there in Ensign Tankers, I wondered whether I ought to hand up that case so you can see what's being said by Lords Templeman and Gough, if I may do that.
You can send it to me electronically.
Right, okay.
I'll have one. Are you going to take us through it?
Yep.
You can ask us to look at it now. Richard, do you want one? Two, please.
Can I hand up three anyway, just in case?
Sorry, do you like
Yeah.
Thank you very much indeed.
So there's a passage in Lord Templeman's speech at 675C to 676F. He refers to the case called Challenge Corporation, where he says he drew a distinction between tax mitigation and tax avoidance. And over the page at 676C onwards, he contrasts tax mitigation and gives some examples. So that's Lord Templeman, and then Lord Gough is at 681B to E. And says, like Lord Templeman, I approached this case on the basis there's a fundamental difference between tax mitigation and unacceptable tax avoidance. So that Mr. Henderson, as he then was, Lancelot Henderson, was drawing upon that distinction on behalf of HMRC and saying the concept of tax avoidance used in section 741 is that concept which Lords Templeman and Gough were addressing and is to be distinguished from tax mitigation. And Lord Nolan accepted that. Now, although, of course, Lord Nolan was accepting that in the context of section 741 and that legislation, it wasn't, in my submission, anything special about that legislation which caused him to accept it. It was simply that section 741 was talking about avoidance. Other sections talk about, for example, obtaining a tax advantage and then define tax advantage. But here we have the concept of avoidance in section 741. And in my submission, that's why Lord Nolan accepted that the distinction drawn by Lords Templeman and Gough was applicable. And I submit that we have the same concept being used in section 1371 about avoidance. It's not about obtaining a tax advantage. It's using the concept of avoidance. And I submit that there is no reason to give it a different meaning in this context. Now, in Snell, Sir Andrew Morritt disagreed. Could I take you to Snell to see what he had to say about that? Maybe Mr. Ewart took you to it, I'm not sure. This is at tab 13. And it's page 62, paragraphs 35 to 37, 35 to 37. Could I ask you to read those paragraphs? Now, if I can just address what Sir Andrew Morritt said in paragraph 36. He says he has difficulty in understanding why the dictum of Lord Nolan in Willoughby is relevant to the construction of that part of section 137. The passage on which counsel for Mr. Snell relies deals with the difference between tax mitigation and tax avoidance. No such distinction is drawn in section 137. Well, that's true, but of course, no such distinction was drawn in section 741 either. All that 741 said was avoidance of liability to taxation. But nevertheless, Lord Nolan thought that that distinction between avoidance and mitigation was applicable. So that the mere fact that section 137 doesn't expressly distinguish between avoidance and mitigation, in my submission, is not a reason to conclude that the Willoughby meaning doesn't apply. Then he says section 137 is concerned with the terms on which a liability to gains tax may be deferred. It provides for a right of deferral to be lost if it's to be used for the purpose not of deferral but of avoidance altogether. So, query, what meaning is he giving to the word avoidance there? Is he not giving it the Willoughby meaning, but simply saying, as it were, permanent deferral? So, deferral is okay, but not if you're not going to pay the tax at all. Is that what he means? But then he goes on, if that is the main purpose of the scheme arrangements, it matters not whether the scheme was formed for purpose of tax mitigation, avoidance, or indeed evasion. And again, what meaning is he given to avoidance there, just before the end of the sentence? Then he says, the plain fact is, as the Special Commission has recognised in the concluding sentence in paragraph 6 of their decision, that the main purpose of the scheme is the avoidance of a liability to capital gains tax. Now, is that assuming the answer to the question, what is meant by avoidance? I'm not sure, to be honest, whether Sir Andrew is really addressing the question, does avoidance here mean, have the Willoughby meaning of something which Parliament, to put it loosely, didn't intend you to be able to do, as contrasted with mitigation, which is something which Parliament has deliberately held out an offer that you have freedom from tax. And then paragraph 37...
This section has not held out an offer to allow you to avoid tax altogether, only to delay it.
Well, the question I would submit is whether or not avoidance covers a case where you are entering into an exchange in order to acquire shares which will qualify for a substantial shareholding exemption. My submission, I'll make it very short, is that the substantial shareholding exemption is an offer by Parliament of freedom from tax in the case of companies to encourage them to invest. It is an encouragement to invest by saying, if you invest in a certain type of company, a trading company, and have the appropriate number of shares or holding, 10% of the capital, 10% of the dividends and so on, and you hold them for the requisite period, then you won't pay tax on any gain that you make. That is a deliberate encouragement on Parliament's part. My submission is that if a company takes part in a share exchange and takes shares which will qualify for that relief, instead of having cash, in other words, it thereby makes the investment which Parliament has encouraged it to make, that is not avoidance. And I would submit that this is fundamentally different from going non-resident. Because of course, if you go non-resident, you don't pay tax as well. But Parliament has not encouraged people to go non-resident by telling them that they won't pay any tax if they do so. It is not, the fact that the legislation says if you're non-resident you don't pay tax is not a deliberate encouragement by Parliament. By contrast, the substantial shareholding exemption is a deliberate encouragement. And I would submit, if you choose to make that investment as opposed to taking cash, that is what Parliament is encouraging you to do and should not be categorised as avoidance in the Willoughby sense.
Put it slightly different. I mean, the facts of this case are not perhaps the best for you to be able to make this submission, as Mr. Ewart pointed out, but in a different situation, if the company that was the purchaser in whom the shares were issued, by whom the shares were issued, was one which would benefit by deferring having to pay, by deferral of the redemption. In a sense, that's the encouragement that you say Parliament is giving to people who invest. I leave your money in the company for a certain period of time and you get an exemption.
Well, can we leave the money in or put the money in? Subscribe for shares.
Subscribe for preference shares,
Yes.
which you can't redeem for a certain period,
Yes.
which is the requisite period that Parliament said you must leave money in a company if you're going to qualify for SSE relief.
Yes. Now, you say it's not the best case on the facts.
Well, simply because there's no financial... I mean, in a sense, I don't think anybody investigated, but certainly the suggestion is that it was no part of... I've forgotten the name of the company. It's DTL. I mean, it's nobody was suggesting that, in a sense, DTL needed the money, or needed the investment,
No.
you know.
But nevertheless, the SSE legislation does not require
Differentiate between different types
whether
of
it's
size
the
of
money is
companies.
needed.
Yeah.
The fact is that the money is at risk in the company, in the sense that if the company were to, default on its debts or whatever, you're going to come out last.
Yeah.
That's all that the legislation requires.
Yeah.
So that it's a limited requirement on the part of the legislation in that sense, that it's not necessary that the company is desperate for the money or anything like that. But nevertheless, within the terms of the legislation, those preference shares qualified, and therefore my submission is that the taxpayer was doing exactly what the legislation was encouraging the taxpayer to do. Now, as far as the Upper Tribunal didn't deal with this point because it said it didn't need to, the FGT did, and if I could just very briefly take you to what the FGT said about that, which is it begins at paragraph 108 on page 98. I don't need to set out what I argued, but I'm just going to take you to what HMRC argued, but what the tribunal said. It begins at 112, going on to 116. Could I ask you to read 112 to 116?
So you've got a factual finding against you, really,
Sorry, which one is that?
in 114.
Well, 114 is to do with the subjective intentions of Euromoney. Now, my submission is that is completely irrelevant because the question of whether something is mitigation or avoidance is not, it doesn't lie in the mind of the taxpayer to determine that. That is an objective inquiry into what Parliament was encouraging you or not to do. So that if I say to myself, I'm going to do such and such and not pay tax, but it's not avoidance because I think Parliament thinks that's okay, my subjective intentions are of no concern to the tribunal. It's for the tribunal to decide, in relation to Professor Willoughby, for example, whether his conduct of investing in the offshore bond was something that Parliament said was okay. It wasn't anything to do with Professor Willoughby's own state of mind, as it were. So that my submission is that the FGT here is asking itself a completely irrelevant question, namely, and equally it does so at paragraph 112 when it says, talks about the subjective intention of Mr. Snell at the time of the sale. It's true that subjective intention is relevant to whether your purposes are to do something to do with liability to tax, but whether that something counts as avoidance or not is an objective inquiry in the Willoughby sense. So that my submission is the FGT went wrong in just asking itself what Euromoney's subjective intentions were and not whether what it was proposing to do constituted, objectively speaking, avoidance. And you've got my submission that it doesn't constitute avoidance because Euromoney was doing what Parliament was encouraging it to do. I think I better stop now and give Mr. Ewart a chance to respond.
I want to put one question to you about
Yep.
this last run of submissions.
Yep.
If you look at section 137, where it talks about avoidance to liability,
Yep.
as a matter of statutory interpretation, you have to see that in the context of a taxpayer who's already notionally has got the benefit of section 135. In other words, you're in a world where you've got something good, you've got a relief.
You're
And
hoping.
you might call that a tax mitigation, because you don't have to pay tax on your shares on your exchange
Immediate.
straight away. You can roll over the tax
Yep.
liability.
Yep.
So that's the context in which you then come to construe 137, at which point you ask yourself whether a main purpose of the scheme or arrangement, and we've had the debate on that, is avoiding liability to capital gains tax. In other words, not paying capital gains tax, which otherwise might be due but for section 135. So isn't the whole Willoughby question baked into section 137? In other words, section 137 tells you where the line is between mitigation, which is legitimate, section 135, and avoidance, which is illegitimate, section 137. It's where you have a main purpose, which is avoiding having to pay capital gains tax.
Well, I would submit that it's not baked in the sense that just because you do something with the intention there should be no tax liability at all does not necessarily mean there is avoidance. I take the point that 135 is giving you a deferral, a rollover. But my submission is that the word avoiding or avoidance, I think it's avoiding, is not saying anything beyond deferral disqualifies you. My submission is that that is picking up that distinction. It is still possible for you to go further than mere deferral, but in a way that constitutes mitigation rather than avoidance. So in that sense, it's not already baked in, it's not already answered by you're doing more than deferral, because there is still a possibility that the more than can count as mitigation because it's doing the very thing that Parliament is encouraging you to do. That's my
So
submission.
does it follow from your submission that in practical terms, every time section 137 is in play, it is open to a taxpayer to say, but we're not in the land of avoidance, we're in the land of mitigation, so that the FTT is going to have to settle down and go through a Willoughby argument as a prelude to deciding whether section 137 is engaged or not.
Well, that is a choice of language on the part of Parliament in my submission. If it has picked up, as in my submission it has, that concept of avoidance as opposed to mitigation, then yes, given that that is a requirement of the section, yes, that is something that the tribunal is going to have to do. It's going to have to grapple with, unless and until they're told that that is not the right inquiry. I would submit that that doesn't count against my interpretation, because, as I've submitted, it would have been open for Parliament to have phrased 137 rather differently and said that the main purpose is to secure a tax advantage, and then, as legislation often does, and then defines tax advantages, including not paying any tax or obtaining a tax relief or something like that. But the word avoiding in my submission is different.
And you say that's because, perhaps, if the reason for you paying less tax, or not at all, is you're taking up a tax exemption from another part of the taxing statute, the SSE exemption in this case, that's legit.
That's legit.
And if you're taking yourself off to another jurisdiction, that's no part of Parliament's tax offer.
No.
And it's not legit.
It's certainly
And that's the difference.
It's certainly Parliament has drawn rules about when it taxes you and when it hasn't, but to take advantage of those rules and go non-resident is not something that Parliament is positively encouraging you to do.
No, but it's legitimate.
Well, I would interpret the word legit as meaning something which Parliament is encouraging you to do.
Something which is accepting part of Parliament's tax.
Well, it's encouraging you to do it, surely, by saying you don't have to pay CGT if you live abroad.
Well, I would submit that not every tax rule is designed to encourage you to do something. Sometimes it's also to collect tax. But
I think your point is there's no countervailing benefit for somebody going abroad. They just don't pay tax. Whereas SSE regime, is designed to produce a benefit for the company into which the investment is made for a certain period.
Yes.
And so, in a sense, there is a quid pro quo for the tax advantage, as opposed to just taking yourself abroad, which has no countervailing benefit at all from Parliament's perspective as part of the tax framework.
Yes. Parliament wouldn't be encouraging you to do something which has no countervailing benefit. I mean, that wouldn't make any sense, I would submit. So that, yes, exactly, the encouragement is there in order to persuade someone to do that which they might not otherwise do, because there's a perceived benefit to, well, the trading company, maybe more widely to the economy, in them doing that. And I would submit that that clearly is not avoidance, but then clearly it's not avoidance to invest in that way. It's not also not avoidance to invest in that way as part of a share exchange. That's my submission.
Thank you. Mr. Hewitt.
I would agree with Your Lordship that this ought to be a simple case. And on the revenues construction legislation, it would be a simple case. You asked my learned friend whether the revenues construction would lead to uncertainty in the law. I'll come back to this, but I would submit it's the taxpayer's construction that will lead to far more uncertainty and difficulties in the law. If uncertainty is a relevant factor. The critical question, as you identified, is the correct construction of exchange forms part of the scheme. And my critical submission, which I think Your Lordship has, is that there is a difference in quality. There's a qualitative difference between an exchange, which is a legal transaction, and a scheme, which is a plan, a way of ordering transactions, if you like, for a purpose. And in that context, it's perfectly natural, as a matter of English, to say that an exchange, i.e. a transaction, can form part of a scheme, even though, as my friend would say, not all the parts of the exchange are operative within the scheme. Because a scheme, particularly a tax scheme, involves a number of steps. Typically legal transactions, will all be legal transactions of some kind. And they're ordered and they're structured in a particular way. That's the scheme. And so you're not comparing like with like. And so I think, with respect, the Venn diagram idea, and my learned friend's logic that if it's part of something, it's got to be, the whole of it's got to be part of it, is not apposite in this context as a matter of English. That is why we say fundamentally that their construction is mistaken.
You like the Venn diagram though, doesn't it? It works for you.
Well,
because you can have a bit of a. I thought the Venn diagram was quite helpful to you.
Well, if you're looking, I think my learned friend would say that it doesn't work because it isn't actually part of it, because the whole of it's not part of it.
No, he says it doesn't.
And I say it is.
You say it does work, don't you? Because you can have a bit of a.
Yes.
I can't remember the way around now, but a bit of an exchange that's part of a bit of a. It is a scheme.
Yes, but I would submit that that's because these are two different things. The scheme and the exchange are two different.
You've still got to have a good meaning of one that works as part of a scheme, and the part of is quite important in natural English.
Yes.
And that's why the Venn diagram, I think, is necessary for you, really.
Well, the wording actually forms part of the scheme, so it's whether the exchange forms part of the scheme, I think.
It's probably even less helpful to you, isn't it? Forms part of.
Well,
I mean, it's not is loosely connected with, or is in some way.
No.
It means it forms part of.
It's actually an integral part of the scheme.
Yes, but
that is what we have in
say
this case.
a scheme. I mean, I don't think we need to go around all this again,
Yeah.
but you say a scheme is something quite different. It's a series of steps in a purpose plan, which is to avoid tax. First you do this, then you do that, then you go abroad, then you go and contact your lawyers in New York, then you register shares in such and such a country,
Yes.
and then you do this
Form a
and
trust,
that and the other,
yeah.
and then at the end of the day you pay no tax. Hey presto, that's the scheme. The share exchange is loosely part of that, whether it's the whole exchange or a bit of the exchange, even though a bit of the exchange would be sufficient for the plan if you closely analysed each stage.
Well, you might say only part of it is relevant, but that doesn't negative the fact that
No,
the entire exchange
that's what
is
you
part
say,
of
it
the
doesn't
scheme.
matter.
Yeah.
I think we get that.
Yes.
We definitely understand the qualitative difference point.
And that feeds into the question of the main purpose of tax avoidance, because then you're looking at what's the purpose of the scheme. Why is it being constructed in this particular way? That's what it's all about. So the purpose of the scheme is tax avoidance. If one of the main purposes of the way it's been constructed is to avoid tax, we would say that's what you're looking at in purpose in relation to a scheme and tax avoidance.
It doesn't follow, does it, that because you could have two schemes of which the exchange might be part. So you might have a scheme which was designed to avoid capital gains tax and a scheme which was designed to avoid corporation income tax, say. It doesn't follow that because you can have two schemes that fall within for consideration through this section, that you're right, that there can be any number of schemes thrown up by the section for consideration. So you might have more than one, and so that the indefinite article doesn't prove you're right. It allows you to be right.
Yes, but the controlling factors are that it has to be a scheme in the sense of a plan for a purpose. It has to the exchange has to form part of it. So if this is a scheme that got nothing to do with the exchange at all, it's doing something else, then it's not relevant to Section 137.
Yeah.
And it has to have as the main or one of the main purposes avoidance of tax. These are the controlling factors. And once you determine that, we would say that's the end of the exercise, and that is straightforward.
Do you do the three stages that Mr. Prosser wants to do?
Frankly, I don't really see why it matters which order you carry them out in, because you have to decide the three things, and the scheme or arrangement has to comply with both of these other requirements. And it doesn't matter really whether you start with finding a scheme that has a main purpose of tax avoidance and asking whether it has the exchange as part of it, or if you ask whether there's a scheme with the exchange as part of it and what's its main purpose. To be honest, it doesn't make, my submission doesn't make any difference.
The normal reading of the statute, natural reading of the statute, would suggest that you start with the exchange, because if it's not for genuine commercial reasons, it fails, full stop, end of story. That's your big first doorway you've got to get through if you're a taxpayer.
And then you might read from left to right.
Yeah,
and say.
I think reading from left to right, from beginning to end of the section, is the conventional way. I mean, that's what
so you start. So you say, is there an exchange? Does it form part of a scheme of arrangements? Tick. Was one of the main purposes of that scheme of arrangements to avoid tax? Tick. That's the end of it.
Well, you say, is there an exchange? Number one.
Yes.
Is it for genuine commercial reasons? Tick. If so, and then you get on to the second stage, but then you're still saying it has to be the exchange in question.
Yes, exactly. Yes, I
so the focus is always on the exchange.
Well, the focus is on the exchange until you get to the scheme or arrangement and you're asking about the purpose, because the purpose is the purpose of the scheme, not the purpose of the exchange.
Correct, but you've got there through focusing on the exchange. What
Yes.
I think one of the criticisms of your approach is that you start at the end of the sentence, and go, can I see a scheme or arrangement somewhere which has an illegitimate
I wasn't intending that to make any
and if
difference.
so, I'll work backwards.
Yeah,
I think that's one of the criticisms.
Okay, well, in my submission, it doesn't make any difference, and I'm perfectly happy to start at the beginning of the sentence and walk the other way, because you're asking exactly the same questions, and you're going to get exactly the same answer at the end of it, whichever end you start with. It may be convenient to look for a scheme of arrangements to avoid tax, otherwise you wouldn't be bothering to look at it at all, just as a matter of practicality, and then look at and ask whether the exchange forms part of that. But you can easily work from the front. It doesn't make the slightest difference, I would submit. And in this case, it makes no difference. You start with the exchange. We say on our construction legislation that it forms part of the scheme, which is quite plainly and openly revealed by Mr. Flint in the email. And we say that the main purpose of that, as has been found by the tribunal, was to avoid tax, is the only purpose of it. We say it's that simple. My learned friend's approach seems to involve, as I understand him, a number of questions of fact for the tribunal to weigh up. I don't really understand the first one, because there seems a contradiction here. First of all, he says, as a matter of construction, you can only look at schemes which have the wider, include everything in them. And if that's right, then of course our scheme doesn't comply with that. But then he also says that the tribunal decided as a matter of fact that this wasn't the right type of scheme, wasn't the right scheme, because it was a matter of reality, they said. And in my submission, those two things cannot work together. One, it must be one or the other. And I would repeat my submission. Now, if you read the first-tier tribunal decision carefully, you will see that the reality point they got from Brebner, and they clearly thought, when they deal with Brebner, they clearly thought that was authority for the proposition, but that the reality was to look at the wider overall transaction rather than as part of the transaction. But I'll leave you to, if you read what they said, you'll see that that's where they get it from. Because there isn't any other reason. If I'm right about the construction of legislation, what further question is there? How can a tribunal then say there's an exchange, bona fide commercial, whatever reasons, there's an exchange, it forms part of a scheme or arrangement, and one of the main purposes is to avoid tax. There is no further question for the tribunal to ask. They cannot then say, well, even though all these requirements are satisfied, we're going to say that it's not real, or the reality of it is not that this should be the scheme. In my submission, there is no further question for the tribunal to ask. So I don't understand where this question of fact comes in. Either I'm right about the construction, in which case this is the scheme that you can look at, and you look at the purposes of that scheme, or Mr. Prosser's right about the construction, in which case you can't look at that scheme, you have to look at the much, much wider scheme. But if he's right about that, we then get into this very complicated question of fact, which would arise in every case, apparently. Even if there was obviously a tax avoidance scheme going on, you would have to then ask the question, well, how important is this tax avoidance scheme in comparison to the transaction? You'd then be comparing people's intentions about the commercial transaction with their intentions about tax, and trying to weigh these up and decide whether the tax purpose is sufficiently great in comparison to the rest of it in order to be a main purpose.
Why isn't that inherent in the concept of the requirement that it be the main or a main purpose? I mean, that is inevitably going to evolve in evaluative judgment.
But not in every single case.
But if you can select,
in most cases, it's not.
If you can select the dimensions of the scheme or arrangement in the way you suggest, you'll get the same answer in every case, which is, of course, it's the main purpose, or indeed the purpose, because we've defined arrangements so narrowly. It's
not a question of me selecting it. I mean, or the revenue selecting it. It is the nature of the transaction. I mean, in a sense, in this case, the taxpayer selected it. They selected these arrangements to avoid tax, but it's not that the revenue can take any sort of section of transactions and sort of stitch them together. You've got to look and see whether there is a scheme to avoid tax, and that will become apparent usually because, well, either because of the terms of the arrangement, it's so obvious that they're designed to avoid tax to everyone, it might be, but usually it's because you look at the facts, and you look at what the parties have been saying to each other, you look at the emails, you look at what's behind it all, and you try and work out that there was this scheme. But it's not a case of the revenue just picking sort of bits out of the transaction and saying, well, if you stitch all these together, then there'll be a tax avoidance scheme. That's not how it wants. There has to be a scheme, which has to be something that is planned, has to be deliberately planned as a whole to achieve that purpose. But if there is a plan, that's one. The question is, what's the purpose? And if the purpose is commercial, because, for instance, for example, prefs are being taken because the purchaser wants to have them because they want to pay later or in tranches or whatever, then that's fine. That wouldn't be a scheme or arrangement, main purpose of avoiding tax. But if it's being designed, as in this case, it's a clear case. This is why this is such a good case in many ways, because if you couldn't get a clearer case of a tax avoidance scheme.
Which brings us on to Mr. Prosser's respondent's notice, where he says it's not tax avoidance at all.
Yes. Well,
I mean, I'm only rushing you because
I don't think I need anything more to say.
We've been round those houses before, Mr. Year.
Yes. My response to this, well, first of all, as regards the suggestion that non-residents have no benefit, one has to consider, why are non-residents not taxed in the UK in general? They are taxed on UK source income. Why are they not taxed? The reason is because they're not in the UK, they're not taking advantage of the benefits of being in the UK. This is in principle. I understand that of course, some non-residents are in the UK or something. But the principal reason why you're not taxable is because you're not in the UK and you're not taking advantage of all the benefits that the UK provides, the government provides through the taxation. So it's simply not, I would suggest, not right to say that becoming non-resident has no benefits. That's the whole point about being non-resident.
It has benefits because you don't breathe our air and use our electricity. And
well, you don't use all the services in principle in the UK.
Yeah. Okay.
You don't rely on the army. You don't rely on the whatever, the bins and the However, more serious. So I don't agree that there is any difference in principle between becoming non-resident and taking advantage of any other exemption within the tax code. My primary submission, as you know, is that I think, as my lady suggested, that in the context of this legislation, what you're looking at is Parliament's purpose in enacting Section 135 and providing the relief, the deferral, and to enter into a scheme arrangements so that deferral actually is not a deferral but a complete exemption, is avoidance within this provision. But I'd also not accept that simply because Parliament provides an exemption, like this is substantial shareholding exemption, that is them inviting you to take advantage of it. It is there, of course, and if you fall within the terms of it, fall within the terms of it. In this particular case, the preference shares qualify because one of the reasons they qualify is because the taxpayer owns the other shares, the ordinary shares. Because, of course, the qualifying holding requires the shares to have dividend rights, etc. But the reason that they qualify on the prefs is not because they hold the prefs, it's because they hold the ordinary shares. So that there's nothing particular in this legislation that encourages someone to hold zero coupon non-voting preference shares. But the opposite. If you look at the legislation, what it seems to be aimed at is holding ordinary shares in a trading company. Now, that's not to say you don't qualify. Of course you can qualify for the prefs because they are shares. But that doesn't really answer the question. So we say both counts. You cannot.
But if the
say this is not
if the intention is to encourage people to invest, i.e., to defer obtaining cash to, as it were, leave an investment in a company, that's the SSE requirement of a certain time. I mean, the fact that the prefs don't carry dividend rights or whatever is it's good, isn't it, for the company's point of view, and in which the shares are taken. They don't have to pay for the money, and they don't pay for the money. They don't have to give anything in return. They just hold the money. I mean, from the company's point of view.
You mean the issuing company?
Yes.
Yes, I'm looking at it from the point of view of the company disposing of it.
Right.
And what it's encouraging them to do.
Yeah, it's encouraging them to. Mr. Prosser's argument is that the SSE exemption encourages the disposing company to invest in another company.
If by selling the shares in the first company.
Yes.
You mean by giving an exemption, you give them more cash available to invest in a further company? Is that
No. As I understand it, the SSE exemption, Mr. Prosser says, encourages people to hold shares in another company.
Well,
for a certain period.
It might say it encourages them to dispose of shares because it gives them an exemption when they dispose of them.
Yes, but they have to hold the shares for a certain period.
Yes.
To qualify.
Yes.
So he says, well, look, what Parliament is obviously getting at here is it requires people to invest in another company for a certain period before disposing.
But I'm looking at what kind of shares it is that it's encouraging you to hold.
And I'm saying
it's not particularly those kind of shares that's being encouraged. But they do fall within the exemption, but they're not. Yeah.
Well, yes, but from the perspective of the company in which the investment is made, i.e. in this context, the company issuing the preference shares, if the shares are issued carrying 0 coupon, no rights to dividends, it's free money for the period. It's better than issuing shares which carry dividend rights or a coupon.
But if these were the only shares you held, you wouldn't qualify for SSE at all. Because the legislation, the qualifying holding has to be in shares which carry dividends.
But you can bolt on.
You can bolt on, yes. My point is that if you're looking, I'm not suggesting that this is the right approach, but if you're looking for what the SSE legislation is encouraging on its face, it's encouraging you to hold ordinary shares which carry dividends and rights in the liquidation, etc. Because those are the shares that qualify you. You need to have to qualify for the relief. It allows you to get the relief for other shares. Whether that's being encouraged or not is a moot question. I mean, I don't think you can necessarily draw that inference from the legislation that that's what it's aimed at, holding 0 coupon preference shares. As I say, if you only held them, you wouldn't qualify. So it's not primarily certainly aimed at those. If it was thought that that was even better for the company, as your lordship suggested, you'd imagine those would be within the qualifying holding.
In their own right.
In their own right, yes.
Yeah.
Okay. Yeah. That's not what this is about.
Yeah, I was going to say I find it difficult then to understand the logic behind the exemption.
It's disposing of it's straightforwardly generally disposing of a trading company. That's what it's giving you exemption for. It's allowing UK companies to dispose of other companies, not pay tax, and then presumably invest the proceeds in something else. So it's not
It's investment in enterprise.
So there's not perhaps a fiscal drag in disposing of companies, but that's broadly perhaps what it's about.
Okay.
I think those are all my submissions.
Well, thank you very much. Any more? Well, in that case, we'll thank everybody for what has been an interesting argument. It won't surprise you to know we're not giving an oral judgment now. We will take time to consider our judgments. When we do, we'll hand them down in the usual way. Please make sure you observe the confidentiality of the copy you get to suggest only editorial corrections and agree an order as to disposal and costs, and if you can't do that, we'll deal with it in writing. Thank you both. Thank you all.